Thank you all for joining me today. Today we are talking about a topic that, for me personally, not only as an estate planning attorney, hits close to home, but I am a mother, and I am a mother of a 17-year-old child and an 11-year-old child, and my 17-year-old is going to be a young adult. And as we all know, 18 years old, you're considered an adult, and this is something that hits very close to home. So I said, you know what? I want to put this together, put it out for other parents that are in similar situation that might not know the importance of having this done, not only for yourself to protect your estate and your assets for your children, but also once your children turn 18, what does that mean in regards to the rights that you have to make decisions for them or not? So it's very important. We're going to be talking a little bit introduction about me. We're talking about the tools that we use in estate planning, what to expect, what is estate planning. If any of you here have never done estate planning before, I know it could be very confusing, maybe things you don't understand or overwhelming. Not a problem. We'll go through those. Do you need an estate plan? And the key components of estate planning, legal steps, the 5 legal steps and documents for your child. Like I told, we are incorporating here once your young adult is 18 or older. And then we'll have our contact information in case you have any questions and want to reach out to us after this presentation. That's what we are here for, not only to inform you and provide you this useful information, but also to help you with your estate planning. So a little bit about me, those of you that don't know me, my name is Alina Nuñez. I am an attorney and I specialize in real estate, estate planning, and probate law. I have been in practice over 20 years. I know I am dating myself, and it's crazy to think that it's been that long, but I did get my bachelor's degree from FIU, and I obtained my Juris Doctorate degree or my law degree from Nova Southeastern. I am a Miami girl, born and raised, and I have my roots very, very much here in our wonderful, amazing city and helping those people here. I am a title agent, and as I mentioned, I handle the real estate side, the estate planning, and probate law. So what are some of the tools that we use in estate planning? These, maybe you've heard some of these words talked about in the news by financial advisors or other people. We deal with wills, we deal with trust, we deal with beneficiary designations, and intestacy, or which is the term that is used for when a person dies and their estate. So what to expect? In this presentation, we'll explore your estate planning essentials, helping you make your critical decisions for your family, assets, and medical care. We're going to discover how to secure your legacy and ensure your wishes are fulfilled no matter your family's situation. That is the power that estate planning gives you, is to accomplish these things. So what exactly, when you talk about, well, what's estate planning? Some people have the misconception of like, well, estate planning is only for rich people, or I don't have many assets, I don't need to do estate planning. These are all the typical things that I hear from my clients. And anybody that has any type of valuable asset, whether it's a property, money, or even personal effects, that is considered your estate. So estate planning is organizing these assets, ensuring that they are distributed and managed how you would like for them to be once you pass away. Or if heaven forbid you are still alive and there's a situation which you cannot manage your own assets, who you leave in charge of to do that. So to give you an idea of, well, what's considered an asset? Your car, real estate, checking and savings account, even your furniture, your personal effects in your home, jewelry, if you have paintings of value, anything like that, life insurance policies, investment accounts, and as I mentioned, any possessions such as artwork or jewelry. That is everything that makes up our estate. It all has a value. Okay. So do you need an estate plan? That's one of the main questions that I always receive is, do I need to do estate planning? I'm not a millionaire. Why do I need to do a trust? Or why do I need to do this? All I have, my favorite line is, all I have is my house. It's very, very simple. All I have is my house. Well, yes, our homes are typically the largest asset in our estate because they have the largest value to them. So with an estate plan in place, you take care of and you control how your assets are distributed and who you name to make sure that your assets are handled the way you want to the day you pass away or if you become incapacitated. Okay, so some of the essential documents, I like to say we have 4 to 5 essential documents. We're talking about estate planning, they're here. Is your durable power of attorney, your healthcare designation, your living will, the last will and testament, and a revocable living trust. And we're going to go a little bit into detail into each of these and what they are, their functions, their importance, and how they make up the role of your estate planning. And as I tell my clients, an estate planning applies to anyone, regardless if you have $100 or $100 million. For the most part, we all have assets that we want to make sure are distributed how we want when we pass. And we all have the rights and should make the decisions of who's going to help assist us in case we cannot make decisions for ourselves relating to our health and any other decisions that need to be made. And that's what these documents cover. And trust me, it is extremely important when you are in that situation. Oftentimes it's an unexpected situation that you have these documents. Having these documents is kind of like an insurance where I hope that you may never have to use these documents, but if you find yourself in a situation where you need them, at least you have them and you are prepared. Okay, so let's talk about first of what is a durable power of attorney. So I'm sure many of you maybe have already heard this term used, maybe even have a power of attorney or have had to be an agent in a power of attorney for a parent or a loved one. So a power of attorney, a durable power of attorney or POA, is where you name someone to act on your behalf and give them the power and the responsibility to excuse me, make decisions as if it was you when you cannot, in case you become incapacitated, in case that physically you cannot be present to make these decisions. So what are some wonderful examples of when a power of attorney is ideal? The first one that comes to mind is if you have an elder parent that is experiencing some signs of dementia. Before that dementia progresses and they don't have the mental capacity to make decisions, that is the key time to make sure that you have a durable power of attorney in place. Because if it's a situation where, let's say, they own a property and now that property needs to be sold because they need to be placed in some sort of an ALF or go live with a family member, and the house needs to be sold and that money needs to be used to pay for their care, that's when a power of attorney would be a super important tool to have, because the agent can be able to sign those documents to sell that property in case that their parent or their loved one or the family member can't sign them because the dementia has already progressed. So the time to have these documents in place and have them executed by the person is prior to that dementia progressing, because if not, once they don't have the mental capacity to sign these documents, then you can't have them done. And then you find yourself having to do what we call a guardianship, which is a legal process and basically having the court involved in overseeing everything that happens with that individual, which is what we want to avoid. With all of these documents that I'll be discussing, the goal of them is to leave that power to you to make your decisions of who you want to be able to care for you in case you cannot. If you don't have these documents in place, the court will make that decision. It becomes costly. It becomes a legal process where now you have attorneys in the court involved in your life and what decisions are made, and it takes that power away from you. So that is the importance of these. So the benefits of having a power of attorney, it's economical, it's affordable because you're preventing these costly court proceedings if you become incapacitated, and it lets you make that decision of who you choose. Maybe you want one person to serve as your agent and not another. That's what this document gives you the power to do. So designation of healthcare surrogate is very similar to the durable power of attorney, but this was specifically to healthcare decisions. Power of attorney can cover everything. It can cover real property. It can cover bank accounts. It can cover managing all of your affairs. The healthcare surrogate is specific to making medical decisions. And we're going to talk about this a little bit later as to your young adults and the importance of this, of having the healthcare surrogate. So if heaven forbid something were to happen to you, let's say you get into a car accident and all of a sudden you are in the hospital, you're in a coma, the hospital's going to ask, okay, well, who can make these decisions on their behalf? That's where it's important to have this document. Because again, absent having this document, then you would have to legally have the court involved to name who the person is that has the right to make those decisions. Just because you are the husband or the wife, or just because you are the natural parent of anyone that's over 18, it does not give you the automatic right to make these decisions. And I know oftentimes the hospitals will go, oh, you're the wife, oh, you're the husband, and they'll speak with you. Trust me when I say, if there happens to be a conflict where all of a sudden, let's say a sibling or the parent comes in, and this is going to be a prime example of the case that I'm going to discuss at the end, comes in, and now the husband and the parents of the person are not in agreement, they're fighting, you're going to see how quickly the hospital's going to go, oh, wait a second. Yeah, no, we need something in writing telling us who has a right to make these decisions. So while everything is kumbaya, the hospital will kind of deal with the parent or the spouse. But the minute there is an issue, they're going to want a document in writing. And that's why it is important to have this, because you pick who you want to make those decisions on your behalf. So who can act as your surrogate? Any competent adult who's at least 18 years of age. I always ask my clients, give me your first preference and then give me an alternate in case that person is out of town or possibly doesn't live here. They don't need to live in the same state as you. I have plenty of clients who name an adult child of theirs that maybe lives out of state. I always tell them preference is that they live locally, especially with the healthcare surrogate, because those usually are used in an emergency type of situation. But they don't have to live here. They do have to be competent and at least 18 years of age. And I always ask, give me a primary and give me a secondary in case that person can't act. Living will. So this is one of our other documents. This is, I guess I would kind of equate it a little bit similar to what's called the DNR or do not resuscitate, but it's different. So with the living will, you are making the decision and you are letting your desires known in writing that if you end up in a permanent vegetative condition, in a condition where your doctor has determined that there is absolutely no recovering from that. Basically, your organs have shut down. They're not functioning on their own. And the only way that you are, quote unquote, alive is by artificial means. You are letting it be known that you do not want this. You do not want the natural process of dying to be prolonged artificially if the only purpose is to just keep you connected to this machine. Now, if there is a hope of you being able to recover from such a condition, absolutely. And the doctors have to do all whatever treatments and procedures necessary. But once it gets to the point where two doctors have determined that there is no coming back from this and you cannot recover, you're letting your decisions know you do not want to be maintained alive as a vegetable and that you want to be allowed to die naturally. And again, this gives you the power. This is you making that decision and not leaving that burden on your family members, or also just not leaving your intentions known, where one side of the family can argue, yes, they want to be maintained alive, and the other side could be like, absolutely not. You know, she or he told me that this is not what they wanted. You can scream it from the mountaintops, but if it is not in writing, we don't know what your intentions are. So this is another document, again, that is extremely important, just like the healthcare surrogate and the durable power of attorney. These are all for while you are alive, but if you cannot make decisions for yourself. The healthcare surrogate and the power of attorney, you're naming the agents to make decisions on your behalf. In the living will, you are making the decision and you are letting it be known to your agents, this is what you want, and they have to respect that, as do the doctors, and follow your wishes. So that is the importance of having a living will and having it in writing. So it specifies your desired unwanted treatments, avoids family disputes, eases the burden, because then they don't have to feel that guilt of, well, did mom want to be disconnected from the ventilator or not? You're making notes, say, these are my desires. If it gets to this point, this is what I want. And it takes that stress of making that decision away from your caretakers. So a last will and testament. I know this term is very familiar. I'm sure you all have heard your will. What's your will? So this is the legally prepared document that states your intentions for the distribution of your assets and your wealth after your death. I always kind of say this is kind of like your voice on this planet when you are no longer here with us. It's your instructions. It's your instruction manual on how you want your assets distributed. So the advantages of having a last will and testament is, again, the control, as I've mentioned throughout this presentation. All these documents give you the control to make the decisions how you want them. So you have the control of what happens with your property. It can save your heirs significant expense and hassle of feuding between them, because you're leaving your instructions known of how you want your assets distributed. You can avoid that your assets to get distributed according to what the law says. They're distributed according to what your decision says. So if you pass away without a will, there's often a misconception that I hear, oh, the state gets everything. Wrong. The state does not get anything. What'll happen is, according to Florida law, Florida statute, they will do the distribution of your assets based on the laws of intestacy. And it's kind of like a family tree type of thing. The court will first look at your marital status, whether or not you are married. If you are married, then it'll look at whether or not you have children. If there's children from previous relationships that are not of your current spouse, then the distribution gets divided differently than if the children are all from the same marriage. If you don't have children, then it'll look at if your parents are alive, then they could possibly have an interest. If they have died, then it looks to your siblings and to see if they are alive, if they have passed, if you have nieces and nephews. It just becomes kind of like a very big family tree of who receives your assets, versus you having that control and saying, I want my house to go to my sister, and I want the money in my bank account to go to my brother, or I want everything to go to my niece and my nephew, until they turn whatever age. That's what these documents do. It gives you that power to control how you want your assets distributed. From personal experience, I have had a client who just has not had a good relationship with one of their adult children. And we do not need to provide or include our adult children in our wills. You can absolutely 100% disinherit an adult child. You cannot disinherit a minor child. But if they're 18 years or older, does not matter. You can leave all of your assets to a charity and not leave anything to your children, and they cannot fight it, so long as the will was done correctly and properly. And I have had clients who have had falling outs with one of their children, and they wanted to make sure that that child did not inherit. If they did not have a will and they did not leave that in writing per will, the law would let them inherit from the estate. So that is the importance of having that. It's, again, giving you the control of being able to distribute the assets how you want them. So another way to do your distribution of your assets is by way of what we call a revocable living trust. Well, okay, so Alina, what's the difference, or why, if I have a will, why do I need a revocable living trust? That's another common question I get. Well, wills are good, because wills give you that power. They give you that ability to be able to distribute your assets how you want. The exception with the will is a will does not avoid probate. So even if you have a will, that will have to go through a legal process, which is called probate, where the will meet short that by a judge determined that it is valid, that it was signed and meets the requirements of the law of the state of Florida. Somebody can try to contest the will if they think that, oh, they took my brother took my mom to a lawyer's office and she had dementia. She had no idea what she was signing and they made her sign a paper and now she left everything to my brother and cut me out of the will. Remember I said a will gives you the power to do that, but you have to have the competency to be able to do that. So a will can be contested if they feel that there's sufficient reason to fight that will. And a situation like that example I just gave you is enough reason. We would be able to fight a will to determine whether or not mom had the mental capacity and whether or not that sibling was, forcing her to sign this document. So and that all would be determined in a court of law. With a revocable living trust, it avoids having to go through a probate. Yes, you can still try to contest it if you believe that it was procured, it was done under false pretenses, but it's a lot more difficult. And with a revocable living trust, you name the trustee that you would like to be able to manage the assets and distribute the assets once you pass away, and it's all done privately. It is not public records, where a will, once you open up a case with the court, that will gets deposited with the court and it is public records. I can log in and look at any probate case and I can see a copy of the will and exactly what the will says. With a trust, you cannot. It is private. You don't know who received what unless you are the trustee and one of the beneficiaries of that trust. And everything is handled outside of the court. Another major advantage with revocable living trust, especially for someone similar to me that still has young kids at home, is if something were to happen to me unexpectedly and my children are still minors, or if they're still like under an age that I feel that maybe they're not mature enough to inherit all these assets, I can leave those assets for my children in trust and have a trustee named to manage those assets for my child until they reach a certain age. So for example, if heaven forbid something happens to me and now my children inherit all my assets, I have an 11-year-old and a 17-year-old. I would name a trustee and I would say, okay, trustee, these assets are for my two children. You manage them, invest them, take care of collecting any monies, anything like that. Use it for them if they need to pay their school or anything that they might need, but they cannot manage the money directly themselves until they turn, let's say, 25. Because by 25, I feel they might have a head on their shoulders and they might be responsible enough to manage those assets. Those are the advantages, and that's an example of a very common way that a revocable living trust is used. Okay, so it manages your assets and you name that trustee who would be responsible for managing those assets once you're not here. So the advantages of the revocable living trust, as I mentioned, your estate is kept out of probate. Your affairs can be settled quickly, private, less expensive. And if your estate is taxable, there are ways with different types of trusts that we can use to minimize the taxes that are paid on your estate. And one little caveat on that, the state of Florida does not have an estate tax. There is no estate tax here in the state. That's why we have so many snowbirds and people who move to Florida and buy properties here. The estate tax is at a federal level. It is currently, I believe, at 12.6 million, and it's set to remain at that level. So anything up to 12.6 is tax-free. Above that, it is subject to taxes, and that is set to possibly change in the year 2026 and come back down to what it was previously, which is I think about 5.3 million, like almost in half. So I'll be calling a lot of my clients up in about a year saying, hey, we need to reevaluate your trusts. We need to reevaluate your estate plan and see how we can fix it so that we minimize any estate tax that would have to be paid if the values do come down of the taxable amount in 2026. And it offers protection against court-appointed guardianship should you become disabled. So if you have a trust and let's say you're still alive, you haven't passed away, but you lose mental capacity, that successor trustee that you named can step in and manage those affairs while you're still alive. So a revocable living trust is a wonderful, wonderful tool for estate planning. And I recommend these depending on your situation. But a lot of my clients, this is a wonderful tool for them to use for estate planning and be able to manage their affairs. So what's the difference between, I briefly talked about it, a revocable living trust and a last will and testament? Well, the trust lets you distribute the property privately. After death, you avoid probate, which remember, a will, you do not avoid probate. And a will becomes public records, which a trust does not. And in a will, you really can't manage, rights and responsibilities and debts. A will is just distribute your assets. So that is a big difference between the two, and why, depending on your specific situation, a trust would be better than a will. Also, revocable living trust can be changed at any time. That's why it's called revocable. So while you're alive, I can change it. So if I name a trustee, a successor trustee, and let's say maybe 2 years down the road, that person passes away, well, I need to then change my trust, because obviously they can't serve as a trustee anymore. So I can make those changes. Or let's say I have a falling out with them and I say, you know what? No, I don't want them involved. I want to name someone else. While I'm alive and while the person is alive, you can make changes to your trust, amend your trust, and you can, in fact, if you decide, you know what, I don't need my assets in a trust anymore because my kids, maybe when you did your trust, your kids were little. Now your kids are adults and you can pass it directly to them. You can do all of that. That's why it's revocable. It kind of grows with you and changes as your needs change. Okay. And it avoids, revocable living trust avoids probate because you have your trustee already named. You put your assets into the trust. And you do not need probate. You do not need a judge involved to distribute those assets because they're already titled into the name of the trust. So for example, any property that you were to put into the trust, we would do a deed legally transferring that property to the trust. If you had a bank account and you want the bank account, or a life insurance policy, or an investment account, and once you die, you want that money to pass through the trust, we would change the beneficiary to be the trust upon your passing. So while you're alive, it's under your name. The day you pass, it is now transferred to the name of the trust, and the trustee then distributes it and manages that asset, depending on what you left said in the trust. So let's switch gears now. Everything I've talked to you about is basic estate planning. Most people think, okay, well, I need to get my estate planning done. You don't really think about what you need to do for your children, whether they're minor children or whether they're children that are just turning 18. So we're going to touch upon certain legal steps that are needed for transitioning your young adults into adulthood, and making sure that they are prepared, making sure that you as their parents are prepared and protected as best as possible. So these are certain things that you should always talk about or look at. Custody agreements, if you had any custody agreements through a divorce that terminate once the child turns 18, you need to know that. You need to know what's going to happen now with those custody agreements once that child turns 18. Same thing with child support. If your child support was up to, they turn 18, then what's going to happen once that child hits 18, and how is it going to affect the child supporting you? You have to check health and insurance documentation. If they're now over age, can they still be on your policy? Can they not? Because again, in the eyes of the law, at 18 years old, you are considered an adult. Same thing with education decisions at the university. Who has the authority to be able to talk to anybody there, make informed decisions, obtain information on behalf of your child, and also any sort of preparation for potential legal issues that might occur that now your child is 18 years of age and an adult. So once your child turns 18, they're an adult. Congratulations. You can't drink, but you can go vote. You can go serve for our country. And guess what? Parents no longer have the right to manage your affairs. That is right. According to the HIPAA laws, you can call a doctor's office and want to request copies of their documents or speak and find out information. And it is a violation of HIPAA if they are 18 years of age and older that they give you that information, unless there is something in writing authorizing it. Does not matter that you are the mother or the father. At 18, they are their own legal adults. So that's why this is very important, especially if your child's going to go away to college, go even in the same state. But here, we're in Miami. If they go to UF, FSU, heaven forbid something were to happen there and they need to go to the clinic or they need to go to the hospital of the university. Well, guess what? They're an adult. They're 18 years of age and they cannot give you legally information. So having these healthcare surrogates allows you to make medical decisions for your child if they're unable to. It's essential for situations when they're out of state. Also, the documents with your child's wishes regarding medical treatment and end-of-life care. I know it's a very difficult situation and conversation to have, but it's one that is extremely necessary. We need to be able to sit down and have that conversation and know what are the desires and the wishes of the individuals if that were to present itself. Also, it ensures that their preferences are followed even if they cannot communicate it. And again, that's all about having that control that we talked about earlier in these documents. It gives you that control. That's the living will. And the durable power of attorney. You can handle any financial or legal matters on their behalf if needed. Let's say, heaven forbid, something were to happen and they need to sue the university or they need to sue the landlord of the property that they're living on off campus. And if they can't file that suit themselves, with a power of attorney, you would be able to file that suit on their behalf. Okay, and it's also important for managing finances and legal issues if they are incapacitated. One prime example that I give is, let's say your child does a study abroad and they go to Spain for the summer. My nephew's at UF right now. He's finishing up and he did last year 3 months in Spain. And let's say, heaven forbid, something presents itself that they lose their bank card or somebody steals their wallet or something, and they call you up, mom, somebody stole my wallet. Can you please call Chase or can you call Bank of America? Because I'm over here in Europe and I can't get, because of the long distance call, I can't get a hold, but I need you to call them and talk to them and put a stop on this. Well, guess what's going to happen? You're going to call Chase and Chase is going to ask you, are you on this account? And if the account is only in your child's name, you're not. And the next question Chase is going to ask you is, do you have a power of attorney? And if you do not have a power of attorney, Chase will not speak to you. They will not give you any information and they will not let you make any decisions, regardless that he's 18 years old or she's 18 years old and you're their mother and they're in your, does not matter. At 18, they're considered an adult. That is why it's important to have these documents in place in case certain emergencies like this present themselves when they're out of state, out of the country, in the university, they get sick, they need to go to the hospital. You're down here in Miami, frantic, wanting to find out what's going on. With these documents, you ensure yourself that you can be able to obtain that information and speak to the doctors and speak to the nurses in case that you cannot, your child cannot make the decisions for themselves. So why are these documents crucial for college students? So without a healthcare surrogate, as I mentioned, you lack the authority to make medical decisions for your child once they are 18. It is critical if they're in a different state and if they need medical care, or even if they're out of the city that you live in. And like I mentioned, UF, FSU, that's a 9-hour drive, and if you need to make these decisions and be able to speak to someone and get information, it's important for them to have these documents. Having the documents ensures that you can act on your child's behalf in cases of an emergency. It helps reduce stress, potential legal hurdles during critical times. There's nothing else that you want to deal with calling and trying to find out. They say, no, sorry, we can't talk to you. And then now you're like, great, what do I do? How do I deal with this? Also, the durable power of attorney, as I mentioned, lets you help manage their finances if they cannot. They retain the rights to manage their own affair. These are all documents that go into effect in a situation where they can no longer make those decisions for themselves, even if it's temporary. It lets you be able to temporarily step in and be able to manage this until they can regain the ability to make their own decisions. Helps prevent complications in handling their financial matters. So if you need to call Chase to cancel that credit card or that debit card, you'll be able to without, having peace of mind, without them having to stress or worry about it. One case I wanted to touch upon, which I think is the epitome of making sure you guys understand the importance of this, is the case of Terry Schiavo. And I'm not sure if a lot of you know this, if you're native to Florida or not, or where, but I am. And this case was at its height when I was in law school. It was in front of the Supreme Court of the United States of America when I was during law school. So this was a very, very, very hot topic and has always kind of stayed in my mind and has always been a prime example that I give to parents, adults, anyone, of the importance of having these documents written. As I tell my children, and they know it, it's better to have them and not need them than to need them and not have it. So the case of Terry Schiavo, she was a Florida woman. She was from St. Petersburg, Florida, up in the Tampa area. In 1990, and again, I know I'm dating myself, she was 26 years old. She had a heart attack, but she did not die. She was in her home. She collapsed to the floor. Her parents were there. She went into cardiac arrest. They were able to resuscitate her, but because of the massive the amount of time that she was without oxygen to her brain, she had massive brain damage, and she was basically left in a persistent vegetative condition. So after 2.5 months without any sort of improvement, without any signs, and she was basically brain dead, but she was alive because she was on a ventilator and on machines to keep her alive. The doctors basically said she is in a persistent vegetative state. She did not have a living will done. Of course not. She's 26. No one at 26 thinks that this is going to happen to them. But unfortunately, it can. Life does not give you what you think you're going to receive. Expect the unexpected. So at 26, she didn't have anything, and she was married. What ensued is 15 years of legal battles between her parents and her husband. Her parents did not want her to be disconnected. Her husband did. He said this is not what she would have wanted. She did not want to be living as a vegetable. Her parents, obviously, this is their child. This is their daughter. I totally sympathize with that as a mother. Kept holding on to hope that she would come out of this condition, even though numerous times over the years the doctors would tell her absolutely not. There is no way she is going to recover from this. 15 years of legal battles, 14 appeals, went all the way up from the circuit court to the Supreme Court of the state of Florida, all the way to the Supreme Court of the United States, where ultimately, after numerous appeals to the Supreme Court of the United States, they finally made the decision to remove her from the life support. And within, I believe it was 10 days of doing so, she passed away. But unnecessarily, this woman was maintained alive for 15 years as a vegetable, her parents suffering by her bedside, her husband suffering by her bedside, and the two of them in costly, drawn out legal battles. This is what a living will could prevent. If she had had a living will saying, these are my desires, whether yes, keep me alive, or no, don't keep me alive, it would have made this situation easy. But she was 26. No one at that age imagines that they need this document, but unfortunately she did. So this is the one case that I use as a prime example, especially since it's a Florida case, and just really sets the precedence and really shows the importance of having these documents. And she was an adult, she was married, and she had her parents, but neither one of them had the absolute right to make these decisions because she did not leave it in writing. And just because your blood versus marriage, that's what they were fighting out over, who had the rights to make this decision on her behalf. And 15 years later, unfortunately, with now her parents destroyed and the husband and everyone fighting it out, the ultimate decision was to remove her, and she did end up passing away in 2005. So I hope this shows you as an example of the importance of having these documents. I know it's a bit harsh, but that is the reality that we deal with. If anyone has any questions, I'm going to be checking the chat. I see here. Okay, how or no, I don't see anything. I don't see any questions in the chat. So if you have any other questions or we can be of support, here is my information, our office number. Give us a call, our social media, follow us. I'm constantly putting out materials and videos and hold these types of webinars to inform you, show you the importance of having everything done. As someone who had a parent that went through having Alzheimer's, that is what kind of led me even more so to go into this area of law, because I know the importance of having that not only for an elderly person but also for a young person. And as a mother to someone that is going to soon be an adult, I find it very important. I want to inform all the other parents of the importance of having these documents in place, and not only for yourself to have your estate planning at a minimum, but also the importance of having it done for your adult children, especially if they're going away to college, to help prevent any unnecessary experiences or emergencies. It's always best to have those already in place and have that peace of mind that they give you. So I hope you enjoyed this webinar. I hope you found it informative. And if you need anything, and if we can be of any assistance, please give us a call. You have our information. And if you mentioned that you attended this webinar, we will include the healthcare surrogate designations for your 18-year-old, your college-bound child. We will include that for free as a thank you for attending the webinar and for contacting us. I hope you guys have a wonderful day and have a wonderful weekend. Thank you.